California just hit a legal dead end that paralyzed the state overnight. City officials now face massive personal lawsuits for touching a single tent in designated zones. The sidewalks have officially become sovereign territory beyond the reach of authority. A hidden clause in the 2026 Survival Rights Act effectively legalized permanent encampments under the banner of medical necessity. Police departments are receiving emergency stand-down orders, leaving neighborhoods in a state of absolute high-stakes legislative limbo. We have uncovered the 10 secret loopholes making these camps legally untouchable. You must see the final rule to understand why your city is powerless. Number 1. The Protection of Aid Workers SB 634. The first pillar of this legal fortress is the explosive Senate Bill 634, a piece of legislation that has effectively turned every volunteer and nonprofit worker into a legally bulletproof entity. Gone are the days when city code enforcement could disrupt the distribution of supplies or dismantle temporary structures. Under the strict protections of SB 634, any individual providing humanitarian aid is now wrapped in a state-mandated shield that forbids police interference. This isn't just about a sandwich or a blanket. This is about a radical shift in power that has stripped cities of their clearing authority. If an aid worker is on site, the encampment essentially becomes a protected no-go zone for sweeps. This law recognizes that disrupting the lifeline of survival constitutes grave harm, a claim backed by breakthrough social research showing that breaking these aid links spikes emergency room admissions by over 400%. For the first time in history, California law prioritizes medical stability over neighborhood aesthetics. For you, the resident, this means the tented cities are no longer temporary stopgaps. They have evolved into protected hubs of activity. When you see a van unloading supplies, you are witnessing the legal hardening of that location. City officials are now terrified to intervene, knowing that one wrong move against an authorized aid worker triggers a massive civil rights lawsuit that could bankrupt municipal budgets. The government has essentially outsourced sovereignty to third-party organizations, creating an unbreakable chain of command right on your doorstep. This is the ground zero of why the streets aren't clearing, and it's the most dangerous legal precedent city councils have ever faced. Number 2. The Defense of Necessity ruling. Prepare for the ultimate legal shockwave that has effectively checkmated every city attorney in California. The Defense of Necessity. In a series of unprecedented judicial rulings finalized in early 2026, the courts have officially recognized that when a human being is faced with the choice between breaking a camping ordinance or freezing to death, the law must side with survival. This isn't just a legal theory anymore. It is a bulletproof defense that turns every sidewalk tent into a court-protected sanctuary. If a city attempts to sweep a camp without proving they have a bespoke, medically appropriate bed available that very second, they are committing what judges now call state-sanctioned endangerment. This paradigm shift is backed by shattering scientific data from 2025 longitudinal studies, proving that forced displacement during winter months or extreme heat increases mortality rates by a staggering 30% within just 14 days. The courts have taken this data and weaponized it into a legal iron curtain. Now, when a sheriff's deputy approaches a tent, they are met not with compliance, but with a necessity declaration, a document stating that the resident has no safe, viable alternative, making their presence on that specific patch of concrete legally mandatory. For the general public, this means the rules of engagement have been completely rewritten. Your local government is no longer fighting a housing crisis. They are fighting a constitutional lockdown. Any attempt to clear these zones without a multi-million-dollar housing surplus is met with an immediate judicial injunction, freezing the city's assets and stopping the bulldozers in their tracks. We are witnessing the birth of necessity zones, where the law of the land is no longer the city code, but the raw, unfiltered right to exist at any cost. The streets are changing, but your understanding of the hidden forces behind them shouldn't have to. We pour hundreds of hours into decoding these legal labyrinths so you don't have to. If this shocking reality moved you, watch our previous deep dive into the 2026 housing crisis to see the full picture. It takes just one click to subscribe and fuel our mission. Don't let the truth stay hidden. Number 3. Mandatory 48-hour notice and storage. The third pillar of this legislative fortress is the transformation of city infrastructure into a high-stakes logistical nightmare, the mandatory 48-hour notice and storage protocol. As of early 2026, the era of the surprise sweep is officially dead. Under the state's uncompromising new model ordinance, cities are now legally forbidden from moving a single tent without providing a stark 48-hour written warning. This isn't just a courtesy, it is a constitutional tripwire. If a city official so much as nudges a sleeping bag before that clock runs out, They are opening the floodgates for civil rights litigation that can paralyze a municipal budget for years. But here is the truly mind-bending part. The law now mandates that cities must catalog, tag, and store personal belongings for a minimum of 60 to 90 days. We are talking about everything from birth certificates to bags of clothing. If a city worker accidentally tosses a functional item into a garbage truck, it is no longer just a mistake, it's a due process violation. Cities are being forced to lease massive warehouses and hire property curators, just to manage the sheer volume of confiscated gear. This has created a massive financial deterrent. Many towns simply cannot afford the astronomical costs of being the state's involuntary storage locker. This legal trap ensures that even if a city wants to clear a park, they are stopped by the terrifying complexity of the chain of custody. For every tent removed, a mountain of paperwork is generated. This is the administrative iron curtain that keeps encampments in place. The streets aren't clearing because the legal price tag of a single sweep has become too high for the taxpayer to bear. You are watching a bureaucratic stalemate play out in real time on your very own sidewalk. Number 4, the pro-housing funding lock. This is where the financial guillotine drops. As of January 2026, California has officially weaponized its multi-billion-dollar budget through the pro-housing funding lock. The state government has sent a chilling message to every mayor and city council. If you don't have a state-certified housing plan, your access to essential infrastructure funds is completely severed. We are talking about hundreds of millions of dollars for roads, parks, and public safety being held hostage. For a city to clear even a single major encampment, they must now prove to the state that they have actively created pathways to permanency, rather than just shuffling people from one block to the next. This isn't just a suggestion, it is fiscal warfare. Under the latest 2026 budget trailer bills, cities that engage in aggressive clearing without meeting strict housing to unhoused ratios are flagged as non-compliant. This label is a death sentence for local projects. A city might want to clear a sidewalk, but doing so could cost them the $50 million grant they need to fix their crumbling bridges. This has created a desperate paralysis within local governments. They are caught in a vice grip between angry residents and a state government that will bankrupt them if they don't follow the Housing First mandate. The science of urban economics confirms that this pressure is intentional. Research shows that cities which focus on permanent supportive housing see a 60% reduction in long-term emergency costs. By locking the funds, the state is forcing a radical evolution of the California landscape. When you see a persistent camp, understand that it's often staying there because the city is scrambling to build the required pro-housing units just to get their own tax money back. The leverage has shifted entirely to Sacramento, leaving local authorities penniless and powerless. Number 5. Protection of survival gear. In a shattering blow to traditional city enforcement, the legal definition of property has undergone a radical, life-altering transformation. As of January 2026, California law has officially reclassified tents, tarps, sleeping bags, and even blankets as essential survival tools. This is no longer just stuff on a sidewalk, it is now legally protected medical equipment. Under the new environmental survival mandate, any attempt by city workers to confiscate these items during a weather event, which now includes standard winter nights or summer heat waves, is being treated as a criminal act of endangerment. This isn't just a policy shift, it is a constitutional lockdown of city resources. The courts have relied on damning new physiological studies proving that the seizure of a single tarp during a rainstorm can lead to a 40% spike in hypothermia cases within the hour. By elevating these items to the status of life-sustaining assets, the state has created a legal force field around every encampment. If a city sweeps a site and destroys a survival kit, they aren't just facing a fine, they are being hit with federal civil rights violations that carry unlimited punitive damages. For the average citizen, the visual impact is staggering. You are seeing camps grow more fortified because the gear is now untouchable. Police officers are standing down, knowing that seizing a survival tool could result in their personal liability in court. The sidewalk has become a vault, and the items within it are the most legally expensive objects in the city. This is the hidden reason why the camps are becoming more permanent. The state has made it financially suicidal for any city to take away the tools of survival. Number 6. The right to legal representation. The sixth pillar is perhaps the most infuriatingly effective barrier to city action: the universal right to on-call legal counsel. As of January 28, 2026, a massive surge in state-funded street-level legal aid has fundamentally changed the battlefield. Gone are the days when a city could simply issue an order and expect compliance. Today, every major encampment in California is virtually retained by civil rights attorneys. These lawyers are no longer waiting in offices. They are embedded in the field, ready to file emergency injunctions the second a city vehicle appears on the horizon. This isn't just a few pro bono cases, this is a systemic legal blockade. Under the 2026 Justice for All initiative, any person facing displacement has an immediate right to a publicly funded advocate. These attorneys utilize a war room strategy, citing landmark 2025 precedents that define a homeless encampment as a de facto residence. The moment a sweep is announced, a legal stop work order is often slapped on the operation before the first tent stake is even pulled. Cities are finding themselves trapped in a cycle of litigation where a single sidewalk clearing can result in years of courtroom gridlock. The staggering reality is that the law now treats an unhoused person's tent with the same procedural reverence as a brick-and-mortar home. Socio-legal research confirms that when an individual has legal representation, the success rate of a city sweep drops by a crushing 85%. Local governments are being outmaneuvered and outlitigated at every turn. When you see a camp that refuses to budge, you aren't just looking at tents. You are looking at a legally fortified zone protected by some of the most aggressive and well-funded legal minds in the country. Number 7. Medical Fragility Exemptions. This is the silent assassin of city enforcement, the Medical Fragility Exemption. As of January 2026, California has implemented a shocking new protocol that requires a health impact assessment before a single person can be moved. Under these sweeping new health mandates, if an individual is diagnosed with a chronic illness, a physical disability, or even severe sleep deprivation, they are classified as medically fragile. Once this label is applied, that individual becomes legally immovable. Their tent is no longer just a structure. It is now a state-recognized recovery site, and moving them is classified as a life-threatening intervention. This isn't just bureaucratic red tape, it is a medical iron curtain. Backed by shattering 2025 clinical studies from the Stanford School of Medicine, researchers have proven that unstable relocation for the medically vulnerable leads to a systemic collapse of their health within 72 hours. The courts have weaponized this data, ruling that a city's desire for clean streets does not override a citizen's right to medical stability. If a city attempts to sweep a camp where even one person is marked as medically fragile, the entire operation is often summarily canceled to avoid catastrophic legal liability. For the public, this creates a mind-bending reality. You may see an entire encampment remaining in place because of the protected status of just a few individuals. The city's hands are tied by a medical legal alliance that has redefined the sidewalk as a healthcare ward. Physicians and street medicine teams now hold more power than the chief of police. If they say a move is dangerous, the bulldozers must retreat. We have entered an era where a doctor's note is more powerful than a city ordinance, making certain camps permanently untouchable under the eyes of the law. Number 8. The tiny home requirement. This is the ultimate ultimatum that has brought California's Clean Street initiatives to a grinding halt. As of January 2026, the state has enforced a revolutionary new housing standard, the specific accommodation mandate. The law now dictates that a city cannot move a person from the sidewalk by simply pointing to a generic shelter bed. Instead, they must offer a dignified, private alternative, most often in the form of a tiny home or a safe sleeping site. The courts have ruled that congregate shelters, where dozens of people sleep in a single room, are legally insufficient to justify the removal of a private tent. This isn't just a policy preference, it is a structural blockade. Under the 2026 Dignity in Shelter Act, if a city hasn't built enough climate-controlled, lockable tiny homes, they have zero legal authority to enforce anti-camping ordinances. This has created a desperate construction race that cities are losing. For every tent on the street, the city must essentially provide a miniature house. Urban planning data from late 2025 reveals that the cost to build these units is skyrocketing, meaning cities are financially paralyzed. They cannot clear the camp because they haven't built the tiny home, and they can't build the tiny home because the budget is exhausted. For you, the observer, this explains the permanent nature of the structures you see daily. The sidewalk has become the default housing because the legal alternative is too expensive for the city to provide at scale. You are witnessing a legislative trap where the state has set a bar so high that local governments are forced into submission. Until a key to a private door is handed to every resident of an encampment, those tents are legally annexed to the pavement. The era of move along is dead. The era of build or back off has officially begun. Number 9. Accountability for waste versus property. This is the legal landmine that has turned every city garbage truck into a multi-million-dollar liability. As of January 28, 2026, the California Property Sanctity Protocol has officially eliminated the city's ability to clear debris during a sweep. In the past, workers could label everything in an encampment as trash and toss it into a compactor. But under the vicious new 2026 guidelines, the burden of proof has shifted. Every single item, from a stained mattress to a crumpled cardboard box, is now presumed to be private property until proven otherwise by a certified inventory specialist. This is no longer a matter of cleanup, it is a forensic operation. If a city worker mistakenly throws away a bag that contains a resident's family photos, medication, or legal documents, the city is immediately liable for conversion of property and constitutional theft. The courts have begun awarding astronomical settlements to unhoused individuals whose homes were treated like refuse. Legal analysts are reporting that a single misplaced backpack can now result in a six-figure payout funded entirely by local taxpayers. The financial terror this has instilled in municipal governments is absolute. Cities are now requiring crews to photograph and document every square inch of an encampment before a single broom is lifted. This administrative nightmare has slowed the clearing process to a crawl, making it logistically impossible to maintain clean streets. Most cities have simply stopped trying, fearing that one overzealous worker with a shovel will trigger a class action lawsuit that could bankrupt the entire department. When you see piles of debris accumulating, understand it's not neglect, it's legal paralysis. The city is quite literally terrified of its own trash. Number 10. The Vallejo Precedent. This is the final unbreakable seal on California streets, the Vallejo Precedent. In a landmark decision finalized just weeks ago in early 2026, the courts established a safety-first doctrine that has effectively outlawed displacement if the alternative is more dangerous than the current encampment. This ruling changed everything. It forces cities to prove, with scientific certainty, that moving a group of people to a new location won't increase their risk of violence, overdose, or environmental exposure. If the city cannot guarantee a quantifiably safer environment at the destination, the court issues an immediate and permanent stay on the sweep. The Vallejo Precedent is the ultimate checkmate. It utilizes cutting-edge 2025 geospatial data that tracks crime and health outcomes in displaced populations. The research is harrowing. When camps are broken up, the residents often fragment into hidden high-risk areas where emergency services cannot reach them, leading to a 50% surge in preventable deaths. Judges are now using this data to tell cities, if you move them, you are responsible for their lives. This has turned every clearing operation into a life-or-death legal gamble that most cities are no longer willing to take. For the public, this is the uncomfortable truth behind why the tents remain. We have entered a new era of legislative annexation, where the sidewalk has been legally redefined as a refuge of last resort. This precedent creates a permanent stalemate. Unless the city can provide a perfectly safe, state-approved sanctuary, the law demands that the encampment stays exactly where it is. You are looking at a new California geography, one where the right to safety has finally superseded the right to public passage. This is the final rule, the one that ensures the invisible wall around these camps remains impenetrable. The 2026 legal landscape has officially transformed California's sidewalks into a high-stakes battleground where the old rules of enforcement have been completely obliterated. What we've uncovered today isn't just a series of policy changes, it is a systemic lockdown of municipal power. From the financial guillotine of the pro-housing lock to the medical iron curtain of fragility exemptions, the state has built an impenetrable fortress around every tent. If you've been waiting for a return to normal, you must realize that this is the new normal. The era of the quick sweep is dead, replaced by a bureaucratic stalemate that prioritizes individual survival over public aesthetics. The staggering truth is that your city isn't just choosing not to act, they are legally and financially paralyzed. We are witnessing a radical social experiment play out in real time, where the right to exist on a patch of concrete has become constitutionally sacred. This is the ultimate wake-up call. If you found this deep dive into the 2026 legislative crisis eye-opening, smash that like button and subscribe to join our community of truth seekers. Comment below, has the law gone too far, or is this the only path to real solutions? Your voice matters in this unfolding revolution.